People, lovely summer's day today. My legs are still playing up. I hope you enjoy this editorial. Let me just show you before I start how much hard work I put in every morning. I'm up at 5 every day till 1 o'clock. This is all my news for tonight. I've got one page to read out. I'll put the headlines on my Facebook. There's 2 pages. This is news on Brexit and Theresa May. Ministers must urgently rein in public spending. Analyses by Bright Blue said Britain has clocked up much in debt. Headlines, I'm only reading that. And then we've got Oscars 2019 winners. Best Picture, Best Actress, Best Actor, Best Supporting Actress, Best Director, Best Animated Feature. Then we've got Chelsea's boss, Chelsea's manager, Maurizio Sarri. Then we've got club's record 71 million signing. So Sarri, the Chelsea's boss, was visibly angry. And then we've got travel and tourism on Ipswich, Suffolk. And then we've got Ipswich Transport Museum, ancient house. Then we've got paternalistic national news on weather. Now I'm going to go into reading some of my politics law book. So we've got the case of the 5 members, 1641. Notwithstanding Elizabeth's evident enthusiasm for invoking the resolutions in Anderson and her similarly pronounced distaste for liberty of discussion in the Commons, neither she nor her Tudor procedures sought to rule as entirely absolute monarchs. Under that, the common law for the privilege of each house against the prerogative, Charles I had ruled between 1629 and 1640 without summoning Parliament. By 1640, his political weakness made out that course sustainably, the newly summoned House rapidly addressed what they perceived as the worst abuses wrought by the King. MPs agreed to levy taxation only after securing reluctant royal support of the Editorial Act and Act abolishing chic money, which also gallowed the judges who had found for the king, and legislation subjecting the monarch's detention power under Anderson to limited judicial scrutiny. For many MPs, however, such measures inadequately expressed what they preserved within Parliament. A motion was subsequently moved in the House to present to the King religious grievances. And for the publication, the Grand Remonstrance of 1641 was detailed many political and religious grievances. The motion offers the first recorded instance in the House dividing on a vote, rather than representing a united front behind which its internal divisions were hidden. A narrow majority of members voted in favour of publishing the remonstrance, and enraged Charles I demanded in the Commons that the 5 leaders of this opposition to its government be tried for reason. The Commons did not comply with the request, regarding it was a gross interference with the deliberative autonomy. The House prepared to equip itself within an armed guard, fearing that the King would abduct the 5 members of the force. Charles subsequently entered the House, backed by 400 armed men. They commanded that the MP identify to impunge members. No MP would do so. In act of some personal courage, the Speaker, William Emphail, in words frequently invoked to demonstrate the Speaker's role of the Commons, defended against whereabouts. May it please your Majesty, I have neither eyes to see nor tongue to speak in this place, but as this house to please to direct, whose servant I am here. Charles' invasion of the Commons was perhaps to participate cause of the Civil War. His Stuart successors nevertheless remained reluctant to accept the constitution forbade such direct monarchical interference with the House's internal proceedings. The Declaration of the Right stressed the constitutional importance of the Commons, independence from interference either from the Crown directly or judges were then appointed by the King and dismissible at his pleasure. Indirectly via the courts, the crucial provisions were subsequently expressed in Art 9 of the Bill of Rights. Article 9 of the Bill of Rights 1689. That the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place of Parliament. Let's have a sip of tea before we go. Quite what status Art 9 possessed in England's revised constitutional order was and remains uncertain. One interception would suggest that by an Art 9 Parliament abolished all pre-existing privileges and replaced them with new statutory formula. The meaning to be attached to the freedom of speech, debates, proceedings, Parliament impeached and questioned, would then purely a question of statutory interpretation for the courts, in respect of which the previous lex ex constitutio parliaments might serve a persuasive authority. Much academic, judicial, and political opinion has still very recently rejected such interpretation. The preferred views appear to be that Art 9 was merely declarative of the legitimacy of the pre-revolutionary situation. The opinion of conceptuality, very problematic. The Bill of Rights, like any other person, revolutionary legislation enjoys a different constitutional status to any pre-revolutionary statute. In respect of the acts passed before 1688 declaring the extent of the privilege, there is no difficulty in assuming that Parliament was merely bestowing added legitimacy on a political concept which arguably enjoyed equal but separate status to legislation. But one might readily assume that the legislation passed by the newly sovereign Parliament could no longer be merely declarative but necessarily transformed by the constitutional status of the issue it addressed. Any claim by the Commons of the Lords that the interpretation of Act 9 was a matter for them alone has no textual basis of the Bill of Rights. Such a claim would also contradict orthodox understandings of parliamentary sovereignty and the rule of the law, which entrust the task of interpreting statutes to the ordinary courts. But one can discern a contextual basis of the Commons which to conclude the judicial interpretation of Art 9. This would derive in part from a suspicion that the Crown Court interfere indirectly with the Commons' operations through its power to appoint and dismiss the judges. However, the contextual justification would largely have disappeared following the Act of Settlement 1700, which empowered the Commons to veto the dismissal of members of the judiciary. What's the judiciary, guys? It's the courts, the courtrooms, the House of Lords. The Act of the Settlement displays rather than extinguished the Commons under suitable fears about losing control its claimed interpretive power. Despite then electric structure of the English court system, the House of Lords unarguably enjoyed a dual judicial status, exercising jurisdiction over its own ex-parliament, but also over the interpretation of statutes and most phases in the common law. For the scope of the common privileges to be determinable by the common law would then mean the fact that they were controlled by the Lords. It was not until the passage of the Judicature Acts of the 1873 and 1875 that could plausibly argue the House of Lords, Cure Ordinary Court, was both formally and functionally independent of the Lords, Cure Legislative Assembly. Although, as suggested below, this initiative was not sufficient to induce the Commons to disclaim its purported interpretive authority. We visit the conceptual problems flowing from the uncertain status and the meaning of Art 9 below, but other issues also merit attention. The following pages sweep broadly over 300 years of the history of parliamentary privilege in five general areas. Firstly, the Houses of Power regulate their own composition through their admission, retention, and explain of their members. Secondly, the publication of details of House business. Thirdly, admissibility before the courts of such published material. Fourthly, the concept of content of the House. And fifthly, the regulation of MPs' ethical standards. Let me just have a sip of coffee and we get to the next bit. The admission, retention and explosion of members. The total development of the Commons electoral system was traced in Chapter 7. However, the Act was gradually extended. The franchise do not fully identify the constitutional principles which have determined the lower house's composition. The relationship between the people and the Commons has also been affected by the questions of privileges. Ashby versus White. The courts had accepted shortly after the Revolution that enfranchised citizens enjoyed common law rights of property in their entitlement to vote. Thus, the plaintiff in Ashby versus prevented him from voting. The judges hearing the litigation had, however, held sharply divergent views on the issue. They noted in Chapter 7 the Commons enjoyed statutory authority to determine the outcome of disputed election between 1604 and 1868, and the result in Aylesbury election was not in doubt, and thus the Commons had no statutory jurisdiction over Ashby's suit. The point of contention with Ashby raised was whether a freeholder's right to vote derived from the common law or from the Commons' power to control its own composition. The question had profound consequences if the latter claim were accepted. It would effectively empower the Commons alone to determine the allocation of the franchise. The majority of judges hearing Ashby's case at first instant accepted the latter viewpoint. He claim bore directly on established Commons privileges with which the court could not interfere. For White and Gold J.J., the matter of the question of the hierarchy. In these matters, the lex parliamenti overrode common law. Holt C.J. dissented Ashby's claim right to vote was firmly based in common law. The judge's duty was to uphold the law. The court should thus hear his claim, and he is the case was well founded, decided in his favour to otherwise would breach the court's constitutional duty. We must not frighten when a matter of property comes from us, before us, or say it belongs to the Parliament. We must exert the Queen's jurisdiction, absolutely respect her jurisdiction, be very pronouncing, very mannerism, very respecting in the Queen's jurisdiction, absolutely. And that's my own adverb towards that criteria. For Holt to extend the privilege was for the courts, not the House, to decide. Patty's case. Let me go to Patty's case. Let me have a sip of coffee before we go to the Patty's case. Quite about 3-4 minutes long. Patty's case. The House of Lords Choir Final Court of Appeal. supported Holt's dissent and reversed the judgment. It is tempting to see a victory for the rule of law over arbit- uh, arbit- arbitrary inclinations of the Commons. For the lower house, it perhaps appeared as a illegitimate intrusion by the upper house, quo judicial body, into its sphere of responsibility. The Commons immediately passed a resolution rejecting Lord's decision in Ashby. Commons any action, any other jurisdiction except the causes especially provided for by Act of Parliament are guilty a high breach of privilege of this House. Shortly after, five other Aylesbury's voters initiated legal actions. The Commons immediately held them to breach its privilege and gallowed them. The equivocal role adopted by the courts was then illustrated by a majority judgment which declined jurisdiction over writs of habeas corpus issued on the voters' behalf. Holt again dissented, stressing the subordinacy of privilege of both common law and statute. Bringing such action was declared in the House of Commons to be a breach of their privileges, but that declaration will not make the privilege that was so before. The privileges of the House of Commons are nothing but the law. The privilege of their concerns the liberty of the people in a high degree, but subjecting them to imprisonment, which was the people cannot be subjected to without an act of Parliament. Substantively, Ashley and Paddy's case have little more contemporary relevance. Conceptually, however, they retain significance because of Holt's assertion of parliamentary sovereignty and the rule of law as constitutional principles superior to privilege. That argument has yet to be entirely settled. But as the following pages suggest, Holt's analysis has gradually gained greater conceptual legitimacy and practical endorsements. John Wilkes, the grievance of the Americans, were not all endangered by British action undertaken of the colonies. The Americans' disenhancement was added by the treatment meted by the Commons and successive British governments to British politicians. Sympathetic to the Americans' cause, John Wilkes' role as a critic government policy has already been alluded to. His career now merits further consideration. Wilkes' early attachment to democratic principles seemed tenuous. In 1757, he brought his way to the Commons by bribing and treating the electors of ironically Aylesbury. Wilkes nevertheless moved in radical political circles, and in the 1760s edited a journal, which I'm pretty much doing, editing the whole book, re-editing, rewriting, and I'm implementing some great artist pictures. You see my artwork, you see how good I am. Vote me as a great candidate as an MP. The North Brighton was disseminated vehement criticism of the government. Issue number 45 castigated the measures contained in the King's speech opening the 1763 parliamentary session. Every friend of this country must lament the Prince that so many great and admirable qualities can be brought to give the sanction of his sacred name to the most odious measures and the most unjustifiable public declarations. Wilkes then published a potentially blasphemous and sedacious trust called An Essay on Women. The combined effect of the two publications provoked the government to prosecute him for libel of the Commons to expel him. Wilkes meanwhile fled the country. On returning to England in June 1768, he was sentenced to 2 years' imprisonment. To modernise, the events of the next year have a farcical hue. but they were considerable significance to shaping emerging understandings of the relationship between the Commons statute and electorate. If a member is expelled, the seat becomes vacant and a boy election is held. Right, I'm just going to pause it there for a minute. I'm not sure what time it's. I'm going to read for another 5 minutes. Vacant and by election is held. Wilkes did not contest his Aylesbury seat after his first exclusion, but Wilkes' status as a convicted prisoner was not the legal impediment to stand for election or taking a seat. Thus, in 1769, Wilkes stood as a candidate for Middlesex, where many electors endorsed his views. Wilkes was elected to the House on 16th of February, expelled by the Commons on 17th of February. Wilkes was returned again on 16th of March and expelled the next day. In April, he was again elected. This time, rather than expel Wilkes and trigger another election, the Commons declared Wilkes defeated opponent the winner, and admitted him to the House. One of Wilkes' supporters tabled a motion inviting the Commons to resolve that no person eligible by law can be anticipated for election by and voted for the House, but by an Act of Parliament alone. The motion was defeated by 226 to 186. The House carried by 224 to 180. A government motion that Wilkes' expulsion was agreeable to the law of the land. The conclusion was not to put to a legal test. Wilkes did not challenge his exclusion in the courts, and thereby missed the opportunity to set up a potentially numerous dispute between the rights of the electorate and the privileges of the Commons. One might initially attribute the House conduct towards Wilkes in the area of political context. The Commons then made no claim to be democratic. 60 years had still to pass before the Great Reform Act was set on Britain on a long, slow path towards a universal franchise. In formal terms, Wilkes repeated exclusion with a defensible expression of the Commons. Traditionally, autonomy from functional perspective, the House action could be construed as a collective expression of Burke's portrayal of the MP as representative rather than delegate. MPs were sparring an ill-advised electorate from the consequences of its folly. If so, one might then assume that the franchise become more extensive and the electorate more mature, and the legitimacy of the Commons legislative role rested increasingly of the assumption that it is represented the people. The House could no longer defensively invoke its privilege to exclude an elected member. But as the experience of Charles Bradley suggests, any assumption will be ill-founded. Charles Bradlaugh, a radical political campaigner, had achieved considerable notoriety by the 1870s, both for founding an aesthetic national secular society. After being prosecuted for publishing a book of birth control, such notoriety apparently appealed in the voters of Northampton in 1880. They returned to Bradlaugh as their MP. Bradlaugh's difficulties began when he tried to take the seat. MP had been placed under a statutory obligation during Elizabeth I's reign to, I'll paint that picture of Elizabeth I's reign, to take an oath on allegiance to the monarch and the Protestant faith before assuming their seats. The oath administrated by the Speaker on the floor of the House was intended to exclude Roman Catholics from the Commons, but also quarter Protestant, non-conformist and Jews. The oath was modified to omit Catholics in 1829. Legislation in 1866 introduced an oath acceptable to members of the Jewish faith, and the Promissory Oaths Act 1868 permitted members of the discontented religious sects to affirm their loyalty rather than their swear it. The legislation did not actually exclude members from the House if they had not, from the oaths or affirmed, but fined them £500 in 1880, an enormous sum for each occasion when they sat and voted without having done so. On entering the House, Bradlaugh, having previously announced himself an atheist, wished to affirm rather than swear his loyalty. The House, however, resolved that he could not do so. Bradlaugh's subsequent attempt to take the oath instead was blocked by a resolution. On declining to leave the House, Bradlaugh was forcibly ejected. The majority in the Commons then expelled him in April 1881. He returned at a by-election a week later, when the Speaker had evidently concluded that the House would do well wisely, according to the Constitution, to admit him without question. The majority nevertheless expelled him again. Bradlaugh was frequently physically ejected by the Commons officials. Undeterred, he has re-entered the House and adopted the extraordinary course of administrating the oath to himself and then assuming his loved place on the backbenches. He was again expelled and again returned ensuing by-election. The Commons' continued refusal to admit Bradlaugh seemingly neglected the impact of the great reformat of Editorial's 1867 franchise legislation in respect of the electors of Northampton. For those voters, the extended franchise was worthless since their chosen candidate was unable to represent them. For Bradlaugh's legal and moral position was clear. He and his electors were victims of the arbitrary and illegal election of the House of Commons. It is a melancholy exhibition of the tyranny of orthodoxy. Then we can see the branch of the legislature taking upon itself nullify laws which the whole legislature itself has sanctioned. He then challenged this arbitrary and illegal action before the courts. The suit Bradlaugh versus Gossett was directed against the Commons Sergeant-at-Arms, who, obeying the Commons resolution, had admitted that he would physically violence to prevent Bradlaugh's entering in future. Bradlaugh's suit asked the court to issue injunction preventing the Sergeant-at-Arms from so doing. A Stephen J. indicated the case raised a straightforward clash between the authority of statute and the privilege. Suppose the House of Commons forbids one of its members to do which an act of Parliament requires him to do so, in such order which one we can declare to avoid a restraint of the executive officer of the House from carrying out. The judgment held no statute could imply after the Commons power to control its internal proceedings. Neither was the House jurisdiction in matters overridden by the common law. In reaching a conclusion, Stephen J. was influenced by a sense of judicial difference to the Commons. The House of Commons is a court of justice, but the effect of its privilege to regulate own internal concerns, particularly invest in its judicial character when it has to apply particular cases the provisions of the Act of Parliament. If its determination is not accordance with the law, this resembles a case of the error by a judge whose decision is not subject to appeal. We were to attempt to rectify ourselves in a court appeal from the House of Commons, which should consult neither of the public interest nor the interest of Parliament and the Constitution, nor our own dignity, since swearing or affirming where procedures conducted entirely within the House, the regulation was solely for the House. In contrast, the House with no authority to interfere with those aspects of the process affecting the composition which... That'll do for now, guys. I'll come back later for reading. That is almost 30 minutes. I hope you enjoy my reading, just showing you my progress going up throughout the book, and obviously rewriting, re-editing all the words in my own concept and adding extra editorial to my pictures. I'm putting in new politicians in my new book to make it updated, limited edition, 2019, the 9th edition by Professor Johnson. So please enjoy my read. It's my intelligence growing. My news is all my own wordings. Everything I do is been intacted, rewrited, re-edited. This is Justin Johnson's new adverb to life resources of 2019. This is my year to become brighter, to become beautiful, to become more sophisticated, to become more intellectual and intelligent. So please enjoy the whole show. Thank you very much. Small steps, but they're making vastly massive, huge steps that people didn't think I had it in me. And let me tell you, I have. I'm doing what I can. I'm going to get where I need to be from A to B or to Z, whichever way may make me go. But I'm working hard. Thank you very much.